If you find yourself in a dispute with your employer and you've read about the concepts of constructive dismissal and wrongful dismissal, you may be wondering which one of these applies to your circumstances. Hi, I'm Mike from Cashion Legal, and in this video, I'm going to cover a question that we often get from employees. Specifically, what is the difference between wrongful dismissal and constructive dismissal? More specifically, I'm going to explain what is wrongful dismissal, what is constructive dismissal, what are the differences between these two concepts, and how they apply to your circumstances. At the end of this video, you'll have a better understanding of the difference between wrongful dismissal and constructive dismissal, and how to navigate through your situation based on that information. Firstly, let's start with wrongful dismissal, because that is the more straightforward thing to understand. Wrongful dismissal is generally focused on a narrow issue related to the end of employment, specifically whether the employer provided the employee with sufficient notice of termination or pay in lieu of notice. At law, employers have an obligation to provide employees with the advance notice of the termination of their employment, but in practice, employers generally provide pay in lieu of notice, providing the employee whatever compensation they would have received had they received adequate notice of termination. People get a little tripped up by the use of the word wrongful in the words wrongful dismissal, thinking it connotes some sort of moral wrong or other thing that the employer did improperly during the termination process. The use of the word wrongful doesn't necessarily refer to the circumstances of the termination other than the issue of whether the employer provided adequate notice or pay in lieu of notice. Provided that an employee is being terminated without cause, a wrongful dismissal doesn't refer to a situation where an employer had poor reasons for terminating employment. In fact, generally speaking, an employer can terminate an employment relationship for poor reasons, so long as they provide adequate notice or compensation instead of that notice. The way I like to frame it for people is that employers are afforded wide latitude in determining the suitability of their workforce. They can terminate your employment if they don't think you're a great fit. They can terminate your employment if things are slowing down and they don't have room for you anymore. Or they can terminate your employment if they don't like the color of your shirt. Provided that your employment is being terminated without cause, the reasons for dismissal are generally not a worthwhile consideration in determining what your employer owes you in connection with the end of your employment. So despite use of the word wrongful dismissal claims are generally not focused on shouting, bad behavior, or toxic work environments. They are primarily focused on the compensation that was provided to the employee at the end of the employment relationship. Now that we have a clear understanding of what wrongful dismissal is, let's move on to what constructive dismissal is. Constructive dismissal refers to any situation where an employer commits a unilateral, fundamental breach of an employment relationship, such that the employee can resign and treat themselves as having been dismissed. In this situation, although it is the employee that communicates the intention to end the relationship, the law treats the employer as the party as having terminated the employee. That's why we call it constructive dismissal. Put another way, the employee quits, but the law effectively says that the employee was fired, and the employee is entitled to whatever compensation they would normally receive if the employer had terminated the employment relationship. What are some examples of fundamental changes that can trigger a constructive dismissal claim? Some of the more obvious examples include pay reductions, demotions, or forced relocations. These are all circumstances where most lawyers would agree that an employee has been constructively dismissed. Conversely, there are situations that are less clear, like toxic work environments, which are a little bit subjective and sometimes difficult to assess. Regardless of the circumstances, in any constructive dismissal scenario, the operative question is not whether the individual employee considers the employer's conduct sufficient to trigger constructive dismissal, but whether the objective, reasonable person would have viewed it that way as well. For that reason, constructive dismissal can be very challenging to prove where there hasn't been a clear objective change by the employer that has resulted in a breach of the employment contract. It is important to note that it is the employee who bears the onus of proving constructive dismissal, meaning that the employee must substantiate to the courts that the employer committed the repudiatory breach that triggers the constructive dismissal claim. This places a high evidentiary burden on employees in constructive dismissal claims and means that they should only be pursued in the clearest of circumstances. Now that we've discussed what is wrongful dismissal and what is constructive dismissal, let's talk about the differences between these two concepts. One of the primary differences between wrongful dismissal and constructive dismissal is who communicates the end of the employment relationship. In a wrongful dismissal scenario, that is communicated by the employer, but in a constructive dismissal scenario, it's communicated by the employee. However, even though this is communicated by the employee in the constructive dismissal scenario, in both situations, the employer is liable to the employee for pay in lieu of notice. This brings us to another major distinction between wrongful dismissal and constructive dismissal, which is the risk the employee faces in either set of circumstances. Wrongful dismissal is actually relatively straightforward because it's usually just an assessment of whether the employee received adequate pay in lieu of notice, and this can normally be answered with reference to the employee's employment contract and other relevant factors. On the flip side, in a constructive dismissal scenario, the employee is required to prove that the employer actually committed a fundamental breach of the employment relationship. This can be quite challenging because employees generally want to rely on their own subjective experience in proving constructive dismissal claims, but the law looks at it from the objective person's standard. This means that when an employee is alleging constructive dismissal, they face an additional burden that they would not face if they had simply had their employment terminated by their employer. In this situation, the employee will have to prove that the changes were sufficiently serious, and in some situations, they'll have to prove that they took steps to address the situation with their employer. Because of the added burden that employees face in these circumstances, constructive dismissal claims are generally more expensive to litigate than wrongful dismissal claims, and the employee generally has less leverage. So why is it important to understand the difference between these two concepts? Regardless of whether your employment's already been terminated or if you're facing a difficult set of circumstances at work, understanding these two concepts is important for informing the right strategy to move forward. If you've already been let go, the concepts of wrongful dismissal apply to your circumstances. And generally speaking, it's not in your best interest to focus on the concepts applicable to constructive dismissal cases. Sometimes we assist employees with terminations who are fixated on the circumstances leading up to the termination of their employment, even though their employment relationship has already been terminated by the employer. Sometimes these employees even wonder whether or not they had a valid constructive dismissal claim prior to the termination of their employment. The reality is that if your employment has been terminated without cause, generally you should focus on whether or not you received adequate notice or pay in lieu of notice in connection with the termination of your employment. There are some situations where the circumstances of termination itself are relevant and may give rise to additional claims against your employer, but for the most part, wrongful dismissal cases are focused on whether you received adequate compensation in connection with your dismissal. On the flip side, if you are facing a difficult set of circumstances at work and you're wondering whether or not you've been constructively dismissed, knowing about the differences between constructive dismissal and wrongful dismissal can help you form a strategy for moving forward. As I outlined earlier, proving constructive dismissal can be somewhat difficult because it's proven on an objective standard, but often relies on subjective evidence from the employee. So if you're dealing with a challenging set of circumstances at work, but you think your employer might terminate your employment in the near future, it may be that you're better suited waiting for that termination to occur, because in that scenario, you would not have to prove that you've been constructively dismissed. This approach would only apply if you had some concrete reason to believe that your employer might terminate your employment in the near future. And to be clear, this is not a hard and fast recommendation. If you believe you may have been constructively dismissed, you should seek legal advice today. However, most lawyers would agree that negotiating your way through a severance package is easier than negotiating your way through a constructive dismissal claim. The bottom line is that wrongful dismissal and constructive dismissal are distinct concepts, with wrongful dismissal being where the employer ends the employment relationship but doesn't provide adequate notice or pay in lieu of notice, and constructive dismissal being where the employee ends the relationship due to a fundamental breach of the employment contract by the employer. Regardless of whether you're an employee who's just lost their job or if you're dealing with a difficult set of circumstances at work, we can assist you with this. We provide employees dealing with wrongful dismissal and constructive dismissal with clarity about their circumstances, strategies for next steps, and peace of mind through sound advice and strong representation. If these circumstances apply to you and you're looking for assistance, do not hesitate to click the link to our website in the description of this video and book a consultation with our office today.